Every day in the USA, people find themselves in court.
Titled in the matter of the marriage of Abby E. Worden and Jeffrey D. Worden, case number 2017 DM 561. Beginning with Abby's side of the case, would appearances be announced for the record, please?
Thank you, Your Honor. Emma Hoffman and Becky Mann on behalf of petitioner Abby McDonald, who appears to my left.
Jeffrey Worden,
Yes, sir.
are you represented by counsel?
No, I have not still been able to retain an attorney.
All right. This matter comes before the court at this time for further hearing in regards to a motion to implement physician-recommended medication, suspend parenting time, and other relief. Ms. Hockman, if you please summarize what relief you're seeking today.
Yes, Your Honor. Well, summarizing briefly is going to be a challenge, but I will do my best. Last time we were before you, we were discussing the need for some modifications to parenting time between dad and the party's daughter, and the need for certain medical measures for the party's son. Since we were last before you, it's been evaluated by a PA, and medication has been recommended to be the next step in treating her mental health and emotional well-being. Our Exhibit A is that recommendation. The recommendation is for a low dose, 10 milligrams daily of Prozac, and the generic name is used in the recommendation. This recommendation has been communicated with Dad. Dad refuses to consent to the recommended treatment plan. I understand that he wants other options, a second opinion, but to my knowledge, no steps have been taken to obtain a second opinion or look for alternative treatment measures. Additionally, I've been evaluated for ADHD. If you remember, we had to get a court order to proceed with that evaluation. Just last week, I had a follow-up appointment to review that ADHD potential. Previously, the PA believed that he had unspecified ADHD, but wanted to wait to recommend treatment in order to hear from his teachers. So we waited until the school year got started, got past the beginning part of the school year, and then had some input from teachers. Now the PA believes that struggles are more connected to anxiety. This was an appointment that happened just last week, so I apologize that we don't have a recommendation in our exhibits. But she believes that his struggles are connected to anxiety and has recommended a follow-up appointment in several months to reevaluate that. The concern with anxiety is supported by Isaac's therapist. As you may recall, we also had discussions about finding a male therapist. Last time we were before you, has gotten started with a therapist, Chris Jones is his name. Likes him, things are going well. Just last week, therapist, Mr. Chris, wrote a letter sharing his observations and his opinions that is experiencing something called malicious parent syndrome. That's contained in a letter that we just received on Friday, so that wasn't submitted with our exhibits, and I'll discuss more about that in a minute. This syndrome that the therapist is discussing is not in the DSM-5, but is a behavioral pattern that's been well documented and has been published about. And a basic summary of that would be when one parent seeks to essentially punish another parent through alienation of the child. That's what this therapist thinks is happening with. We got this letter on Friday. It describes some of the concerns that the therapist has regarding his father. I'll read from it very briefly. Reports his father frequently discusses adult and legal matters during visits, speaks negatively about other, places him in situations that create emotional conflict and anxiety. As a part of this letter, the therapist states, or as a part of this letter, the therapist recounts certain quotes, statements made from, he's using that as a way to put a basis on his opinions to kind of back that up. So statements are contained within this letter, but the therapist states that sharing these statements directly with the father or his attorney would not be in the best interest of the child. The statement should not be disclosed to the father directly. And essentially, the therapist is saying that he fears retaliation against if such statements were shared. So we did get this letter just on Friday, but haven't circulated it because of those concerns. And we can certainly discuss more about that. On the topic of emotional retaliation, we understand that dad has engaged in some inappropriate conversations with the party's daughter, and our motion recounts a recorded lecture from dad too that was happening over a trip. I think it was like a family vacation on dad's time. And I'm sure your honor has reviewed those, but I mean, essentially there's some pretty concerning statements that dad is making to that's putting, at more risk of emotional dysregulation. We already know that she's having issues with her anxiety, with her mental health. We have recommendations from a PA to proceed with medication, and now dad's making these statements too. That's obviously making her incredibly uncomfortable. So we are in a tough spot. Essentially, the relief that we're asking for specifically today is a suspension of parenting time between dad and we don't think that the parenting time is going very well. Dad's making these statements. Dad has volunteered away some of his time with as documented in our motion. We don't think that suspending parenting time between dad and would be beneficial. And our therapist agrees that ceasing that visitation wouldn't be beneficial, but something does need to be done. We are open to suggestions from your honor. We're asking for sole medical decision making for mom due to the constant roadblocks that dad puts up regarding the kids' care. If we were to remove that delay that comes from needing to get dad's consent to move forward with medical and therapeutic measures, and remove the delay that comes from needing to go to court to get a court order to proceed with the necessary care for these kids, maybe the emotional well-being of these kids would improve. But we are open to suggestions.
All right, Ms. Huckman, let me stop you there.
Okay.
Your motion before the court says mom does not request IW's parenting time with dad be modified at this time. Now you argue something differently.
No, your honor. We're saying we don't think that modifying dad's parenting time would be beneficial. Keep it the same. It's with dad that we're concerned about. Right. I apologize if that wasn't clear.
So what time would he have currently?
Currently, he has every other weekend after school to Sunday night, correct?
Yes.
And then every other
Monday morning.
to Monday morning school drop off.
Yes.
And then Tuesday
or Thursday,
and
depending
then,
on the week.
Yeah, 1 week Tuesday night and the other week Thursday night, and that's the time that that's with dad right now.
Okay, why wasn't this other letter shared with Mr. Worden prior to this hearing? I mean, you have his email address, right?
The letter with the therapist?
Yes.
Because of those concerns that the therapist specifically stated that not to share it with dad because of fear of retaliation. We wanted to wait to get before your honor. I know he does have a right to it. If he wanted to participate in therapy and reach out to the therapist, I think that, he could request the letter himself. I think that I don't have a problem sharing this letter with statements redacted, because that was specifically what the therapist's concern was, that if dad reads words, that there would be some form of retaliation. I'm happy, and I know that I'm referencing this letter, and we didn't provide a copy to the court. We just got it on Friday. I'm happy to send it to your honor, but the reason that it wasn't circulated with dad is because of those specific concerns from the therapist.
All right. I think counsel's done a good job of summarizing what they're seeking today and why at this point. Mr. Worden, what is your response?
Well, my response is that she has continued to do this exact same thing, to used your court to push her agenda, the exact same agenda, for 10 years, Your Honor. We did this again. We did this 6 months ago, the exact same thing. We did it the year before that, the exact same thing. We did it the year before that, the exact same thing, on and on and on back, because she's able to get a little bit of ground, gain a little bit of ground from your court every time, apparently, in taking my children away from me and trying to end up getting them both on medications is what she wants to do, and what she has been pushing to do for 10 years. They've been in counseling that entire time since the divorce, since they were little babies, since they were toddlers, Your Honor. They have told me constantly since that time they do not want to be in counseling. The counseling has not helped them. They've continued. Both of them have told me that hundreds of times. Both of them have told me hundreds of times they don't need to be, they don't want to be tested. They don't want to be on medications. They don't want, and they don't believe they need them, just as I have never believed they needed anything like that. She has pushed and manipulated counselors and doctors for 10 years to try to push her agenda. You asked me 6 months ago, I really still have no clue, but the only information along these lines that has ever come out in terms of these children, she's been pushing the ADD and ADHD thing for years. She has found a couple of counselors in that time that said maybe he might, have a problem with that. But every teacher, every principal, his Cub Scout leaders, his choir leaders, all of my family and relatives, everybody else that he and have been around have felt like, as well as me, have felt like these kids are great, including you, Your Honor. You've had them in your chambers twice, once 5 years ago, once 6 months ago. Both times you talked about what great and mature kids they were. You specifically said that my son, back when he was 7 years old, it seemed like he was about as mature as an 11-year-old. Both kids, both times told you also that both times I told you that he wanted more time with me. He always has wanted to spend more time with me. Both times has said that she's fine with the time that she had, which was, every other weekend. We originally had 2 days a week. A couple sessions ago, you cut it down to 1 day a week. And then the 6 months ago, you okayed for them to take away from me on weekends, and said that, it seemed like 4.5 hours a week is sufficient, even though she told you our relationship was fine. We have not had a strained relationship, other than what her mother has caused through exactly what she said, the alienation, trying to alienate me and my kids' relationships all along. She's done that since the divorce, since they were 2 and 3 years old, or since she kicked me out of the house. Excuse me. The divorce was finalized in 2000. In 2020. But these kids, it's just been an ongoing agenda that she has used your court for, to keep pushing the same exact thing. I can go down through this list, every one of these points that they've made for this, if that's appropriate for me to do, but every one of them is is wrong. I mean, it's just there's just, she's been lying and slandering me again for 10 years in your court. And the situation has never been presented, the true situation of our family and of my relationship with these kids and their relationship with me, and has never been presented in a truthful light by her or her attorneys. The only other agenda she's had besides these two that I mentioned are, taking, trying to get more and more money, that she's done also little by little by little, which is totally unreasonable as well. Like I said, I haven't been able to even retain an attorney the last two court sessions. And again, the last time she notified me on the day of, and I called you to try to get an extension, and you didn't allow that. But same thing this time. I mean, she, her attorney postmarked this on the 18th of October, which was 9 days ago, and that, I didn't even get it in my PO box until after that. But I mean, I don't know how I'm supposed to, each time I've just lost ground with my kids, and they've been put in a more precarious situation with all this counseling, with the ongoing counseling and the ongoing her fighting to try to get people to say bad things about my kids. She's done that to the teachers at school. Multiple times we've gone to parent teacher conferences, and they've told me the teachers have told me that there's absolutely no cause for any concern. That, I've been told by the principal and teachers that
You realize that's all hearsay, Mr. Warden. We certainly don't have any documentation of any kind that really is their position. And do you have any contrary medical evidence to contradict what these therapists are recommending to the court at this time?
To me, there's no medical evidence there. I mean, yes, I went back and had a reevaluation on the end of last week, and they said in the Sarah that she was talking about, that he's been seeing at Dr. Mitnall's office, said that no worries. It's what he told me. I did not receive any information from any of this, but my son told me that in their meeting, she said, no worries, that you took these tests at school. She had him take the Vanderbilt tests at school, and she said based on, after all these years of saying that he has these problems, she finally told him last week that based on this information and these Vanderbilt tests that she has totally changed her mind on that, and that he does not showing any ADHD or ADD. Now, obviously, she's trying to say that there's something else. Now they're saying it's something else, anxiety or something again, like they've been saying about. But they're also saying that she has sleep problems and all kinds of things, Your Honor, that they have never had at my house. I mean, to me, all their problems are coming from her house, if they're having problems, because, I mean, she just said in her statement here, for the past several months, Worden has exhibited signs of anxiety and depression. Well, the last 6 months are the time she's not even been able to be with me on the weekends. And I haven't even had 4.5 hours a week, which you had given me 6 months ago, because she's been in sports the whole time. She's been in volleyball, and her games are on Tuesday nights, the same nights that I have her. And so, yeah, there has been times I haven't been able to even see her the 4.5 hours a week.
Do you go to her games when she's playing on one of your nights?
Yes, I go to them many times.
Right. Well, I just saw the reference in the motion that you hadn't exercised a couple of your visits in September.
That's total baloney. That's just a total lie, Your Honor.
Okay.
I've worked together with them, with her and her mother on these different games. Sometimes the games are clear out of town. They're clear in West Wichita. And we live out past Augusta. I live out past Augusta. And sometimes she's had an extra game or something that same night, like 2 games, and there's been time when I've had to be back at the school to pick up at the time that I'm supposed to be over there at her game. I mean, this has happened constantly over the past 6 months, to where there has been several times that I have not been able to spend hardly any time with her on my few hours a week that I have available because of the sports. Same has happened with, I mean, he was in football and it ended up playing games on Thursday night. I mean, yeah, I went to several of his games, the home games, but I mean, I wasn't able to, he had to ride the bus the other night, so I wasn't able to, have my visitation time with him. So it's dwindled down to nothing with, though. I mean, she's been spending all 99.9% of the last 6 months with her mother. And apparently that's when she's been so depressed and anxious. And also that also coincides with the time that her mother decided to provide phones and full internet service to both of my kids without checking with me as well. And so they're dealing with that. I mean, apparently on one hand, she thinks they're responsible enough to handle a phone and internet and all the things that go along with that. But yet at the other hand, she's constantly trying to say they've got disorders and problems and they're just, not doing good in all kinds of things. Which is just not the reality that I experience with those kids, or that, as I said, their teachers or principals or other leaders have experienced. The only complaints about these kids have come from their mother and from some of these counselors that she has been able to influence. And I mean, there's just no truth to the case they're trying to build here, Your Honor, against me and against my lack of, saying that I have a lack of being involved with their involvement in their medical or psychological issues.
Did you tell your daughter that her mom's plan is the devil's plan?
I don't know that I told them that specifically.
Why does your screen keep moving around? Mr. Warden, can you just stay in one place? Because I don't want to get motion sickness during this hearing.
Sorry,
So maybe just stay in a fixed location. Okay, so you don't recall saying that to your daughter?
Not specifically, no.
Not specifically. Okay. Ms. Hochman, in light of the fairly restrictive amount of time between father and daughter that the existing parenting time order reflects, why is it necessary to curtail that time even more?
I mean, everything that Dad has just said, we know that he said it to. We know that he's bad-mouthing Mom in front of. We have the video of him. This is a transcription from that video that took a recording of. It's part of our exhibits. Honestly, Your Honor, we're asking for help. These kids are not doing well. They're great kids. Nobody is arguing that these kids are not amazing kids. They're super involved. They're gifted, but they're having emotional struggles, and it really does appear that it's coming from one place. It's not that we're trying to take away a relationship here. We're trying to get creative of how do we fix this? The kids are not doing, they could be doing better. And we're looking for any solution that we can. We are open to suggestions if you have a different idea.
If this court were to authorize the medication, which has been strongly recommended, counsel, and presuming that this medication has any type of positive effect on the moods of the daughter in this case, then why couldn't she, while still being under therapist care, have the still limited time with her father?
That is definitely a solution, Your Honor. As I stated, if we are able to take away the significant delays in getting these kids care, perhaps their mood and perhaps their relationship with their father would improve. We would be open to that.
Mr. Worden, I understand your concerns. However, this court's in no position to second guess the specific strong recommendations of someone that has claimed, at least, that they've done a thorough evaluation on your daughter and her current needs. If the court will approve and overrule any objection by the father to the mother administering the medication as prescribed in the letter, let me ascertain the date. It's hard to read in its current form. It appears to be July 3rd of 2025.
That's correct, Your Honor.
All right. Court will specifically approve that medication be given to the daughter effective immediately. However, this court is extremely hesitant to further limit parenting time between father and daughter. I would hope, again, that this medication will have some perhaps calming effect or take a little bit of animosity out of the situation. Mr. Worden, I'm going to caution you again not to run down the mother or discuss your court case in front of your daughter. I would think that with such limited time, you do nothing but everything in your power to enjoy the time that you have with your daughter without bringing this case into it in any way, or criticizing her therapist, whom I'm expecting to have a good relationship with your daughter. I want her to be honest and frank with her therapist and not worried about what her parents are going to think about what she tells them. So the court is granting at this time limited relief on the motion, which is currently before the court. Court at this time makes no adjustments to the parenting time schedule involving either one of the Worden children. I'm also hesitant, counsel, to grant a blanket order in this case that only mother can control future decisions regarding medication. And apparently that's what you're requesting at this point.
Anyway.
I mean, there has been, yes, to the extent that there has been significant delays in getting the kids care. We have to go to dad, who is blanketing, saying no, he does not approve of the therapy. He thinks the kids shouldn't be in therapy. He doesn't think that the PA's recommendation should be played out. He thinks that mom's making all of this stuff up. We have to go to court every time that we need some sort of medical or therapeutic intervention in these kids' lives. And he doesn't participate in the appointments. He doesn't reach out to the medical individuals. It doesn't seem like he's interested. So yes, we are asking for sole medical decision-making power. If you are uncomfortable with that, perhaps we could say that if there is some sort of medical recommendation from an authorized medical person, that mom be allowed to carry that out. My mom isn't making this stuff up. She's getting the appropriate evaluations. She has the kids in appropriate treatment, and she's just doing what the experts are telling her to do. And if you look at our motion, we ask that in the alternative, if we can't get the sole medical decision-making power, that be allowed to go on medication, which you granted, and also that mom be able to follow through with any recommendation that somebody this PA in this case makes regarding his ongoing struggles in school and his behavior.
You're talking about Mr. Jones at this point, correct? In regards to,
No, I'm actually referring to the PA, Sarah. That would be our Exhibit C, which is also hard to read. This is the Exhibit C is now no longer the most updated recommendation or summary evaluation from the PA. As I mentioned, they just had an appointment last week. She now thinks that we're dealing with some anxiety and we're going to need some more follow-up because of that. It's a process. These kids are changing, they're growing, developing, and so we just want to be able to implement any sort of recommendation that's made without undue delay. The fact that we're probably going to have to come back to court to implement a recommendation, if it is ever made, is concerning.
Mr. Warden, you would recognize, would you not, that the mother has the right to seek emergency care for your children if they get hurt?
Of course, and I've always gone along with and agreed on any necessary or normal medical or other
Who determines
types
what's
of treatment.
necessary, Mr. Warden? You? You are a medical professional. Who's in the best position to make the decision as to what's actually necessary regarding medical care? I mean, do you have a medical degree or medical training?
No,
All right.
Your Honor, I don't.
And again, I would also agree that Abby doesn't have that type of training or should be clothed with that kind of blanket authority to make all medical decisions for your children. But what apparently her approach has been is to seek help from appropriate medical professionals and then follow their recommendation. So it doesn't appear to be her unilateral decision about starting her kids on medication, which this court wouldn't necessarily agree with, but rather to seek the help of a licensed professional and follow their recommendation.
Your Honor,
But you
she's
have a
been
problem
fighting for
with
that
that.
for years.
Excuse me?
She's been fighting for that for years, Your Honor,
Fighting for
in
what?
your court to try to get those kids diagnosed and put on medications. That's what that has been her goal and her agenda for years. So, and she does have a lot of she is a nurse and she does have a lot of medical people in the industry, doctors and other people that she has manipulated and tried to get her what she's once done, Your Honor. She's done the same thing with the counselors, and she's done the same thing with the teachers at school and the principal at school. I mean, she's just done it for years and years and years. I mean, it's not hard for me to see what she's been doing.
And what is the adverse effect for your children if they receive medication prescribed by mental health professionals? I mean, what is your real concern here about your kids?
To put my 11-year-old girl on Prozac, I think that's wrong. I think it's unnecessary. I think it's wrong. I think there's absolutely no reason for that, anything like that at all, as her father. And as knowing her as I know her and seeing how she's grown up and everything else. I mean, I am her father, Your Honor. God gave me to her as her father. And, God gives us a certain amount of wisdom about our kids, I believe, and common sense and logic. And, I've seen what's happened, what her mother has done for 10 years. That's why I called you this morning and brought it up on a voicemail.
Don't do that.
If you go back and look at all the
don't try to communicate with the court behind the other side's back.
Huh? What's that?
Don't try to communicate with this court behind the other party's back.
Your Honor, I protested this morning before court. I protested this hearing.
I don't know what you mean by protesting. You were wanting to delay this hearing or not have it at all, or I'm not sure what your message said because I didn't hear it. I didn't get it, and I'm glad I didn't. I'm just telling you, that's improper for you to do that, so stop it.
Oh. I didn't know it was improper for me to communicate with you before the
Yes,
hearing.
it is.
I thought that's how we were supposed to ask for
Ask for what?
continuance and things like
You
that.
come on the meeting and ask for it then, which you did not do.
I did last time, 6 months ago.
All right. Well, I think you know the court's position now. Okay. The court will direct Ms. Hockman that your suggestion regarding redaction of actual statements by is approved, and then I want the communication otherwise to be immediately sent after this hearing by email to Mr. Worden following that redaction. I do agree that there is a concern there about the candor that we want from the kids when they speak to medical professionals. And I don't know just how much
The mother,
that affects, but
We'll get
how
that
could
done.
the mother be allowed to hear it?
well, I get the distinct impression it's concerns over what the relationship between you and it might be.
Judge, can we please confirm Mr. Warden's email address?
Mr. Worden? Is that what you have, Ms. Hockman?
That's what I have.
All
That's
right.
what I have too. Just wanted to be sure.
All right. Ms. Hockman, you're going to need to prepare a written order of the court's authorization regarding the medication. And I do want that letter specifically referred to
Will do.
in your order, so make it perfectly clear what the court is actually authorizing.
Okay.
At this time, the court is not modifying the actual parenting time rights of the father. Let's see what following the therapist recommendations makes, and perhaps will make the transition between mother's home and father's home more smooth. All right, Ms. Hockman, is there anything else that we need specifically addressed at this time? I didn't hear a response.
I think Becky might have a better idea.
I am unclear, Judge, as to whether you did make a ruling regarding the medical decision making. You asked Dad, you started to talk about it, and then you asked Dad what his main issue was, and if either party had medical decision making, and Mom was just following recommendations. But I know Ms. Hockman had asked that in the alternative, especially regarding future upcoming expected future recommendations from either the therapist or Sarah, the PA, we would anticipate there be some recommendation that's different than what the current one is, and that we would have to come to court again. And in the alternative, I believe Ms. Hockman was arguing that we be able to just proceed with whatever those upcoming recommendations are regarding, if that makes sense.
And are you talking specifically about medication management for?
I don't know, honestly, and Ms. Hockman can specific, maybe be more specific, but from her previous argument, it was that he had an ADHD evaluation, the court, and that was court ordered. There was follow-up last week, but then that person said that it was perhaps more anxiety related, and there's going to be another follow-up in a couple more weeks. And now he's with Mr. Jones. And Mr. Jones made that recommendation that we need to provide to the court and to Dad, because we just got it on Friday. And so I think there's going to be something, and it might be medication or it might just be therapy related, but something is certainly going to be coming down the pipe in the next couple of weeks after the PA gets back in her office. So I think we just need a little guidance on that.
Court will approve a written recommendation from either his male therapist or the PA or another qualified physician regarding medication management in regards to both children.
Thank you.
I'm detecting, Mr. Warden, that these medical decisions are going to get nothing but resistance from you, regardless of the basis for the recommendation. For now, if the mother believes that following these recommendations is consistent with the best interest of her children, the court will allow those specific recommendations to be followed, as long as these written recommendations are provided to Mr. Warden as they happen. He has a right to know what's going on.
I have a right to not be involved in that with joint custody too.
What was that, Mr. Warden?
I have a right to be involved in every decision along those lines according to the laws of joint custody.
Well, I understand your
In this
protest, Mr. Warden, but where welfare of your kids is involved, the court has some overarching authority to make orders consistent with the best interests of those kids. And again, I don't have anything from your side that presents a contrary medical opinion that this is not in the best interest of your kids. And until I do, I'm inclined to follow the recommendations of qualified mental health professionals.
I don't believe they're qualified.
All right. Does that provide the direction that you were seeking?
Yes, thank you.
All right. Again, if that would be drafted up into an order and in due course submitted to the court.
Will do.
Anything else, Ms. Hockman?
I don't believe so. I think that covered everything. Thank you.
Mr. Warden,
Yes.
enjoy your time with your kids.
Wish I could, Your
And
Honor.
try to not apply pressure on them. If there's nothing further at this time, then the Warden matter will be in recess. This meeting may be ended for all at this time.
Thank you.
Thank you.